Hello, my name is Phil Pluck. I'm the Chief Exec of the FCSA. And over the last few months, we've been doing a series of IR35 seminars, mostly to try and inform the entire supply chain as well as contractors as to what to expect on the 6th of April this year when the reforms come into place. In this particular seminar, we're concentrating very much on what the IR35 changes mean to agencies and to end hirers. And in that respect, we're going to be looking at what is a status determination statement, how does it apply, what do you need to do, what are your responsibilities, in fact, what is an end hirer as far as the supply chain is concerned, and how do you engage with different supply chains, i.e. overseas, UK-based, and actually what your liabilities are within those supply chains, depending on where you sit within them. So that's the summary of what you can expect to see in the next few moments. And it's been presented by one of our IR35 experts, Chris James, who also happens to be the chair of FCSA. So Chris, over to you.
Hello, this is Chris James, here to talk to you today on an FCSA webinar about the new off-payroll rules coming into the private sector in April 2021 and how they impact agencies and end hirers. Today we're going to go over the old IR35 rules and the new rules, the public and private sector versions, because they're not exactly the same. What's on an SDS, what that is, and who is the end user, these important issues around the legislation. So these are new terminology of what they are and what they mean. What happens with an overseas supply chain? How agencies and end users can become liable for taxes and therefore what steps you can take to try and avoid that happening. Whether blanket bans are a good idea. And a project plan, we'll go through some of the steps you need to take, even if you haven't started yet, even though when I'm talking now, we're only a few weeks away for implementation on the 6th of April 2021. The importance, of course, of knowing who's in your supply chain as you bring new people into your supply chain potentially. It's very important to know who they are and what their history is, and that you can trust them. And FCSA's summary overall of what the new rules are and how we can help you in working with the new rules going forward. But of course, it's worthwhile reminding you that off-payroll is very complicated. This webinar today is intended to give you a high-level overview and suggest strategies that might help you deal with the legislation. But you do need to consider taking advice based on your own situation. Very strongly encourage you to do that. Take advice from your legal advisors and people who know how your business works. I'm Chris James. I work at one of the FCSA's member companies, JSA Services. I'm here today as a member of the board and the chairman of FCSA. And in my work with FCSA, I have met with the people at HMRC who have written these new rules. And so I understand what they're trying to achieve. I may disagree with them in some areas about how they're trying to achieve it, but I do know what they're aiming at, and therefore that's why I'm quite conversant with how these rules operate. And why I'm talking to you today. So let's just remind ourselves about how a recruitment supply chain looks. This one has a PSC in it. That's a personal service company. You can see that there in the third block down. That company is called Dave Limited. It's just obviously an imagined name, and it's owned by a guy called Dave. He's going to do the work normally that we're talking about for this piece of work in this supply chain. And so his own company there that he and possibly family members of his, but probably just he, will be a shareholder of and director of. And that PSC, Dave Limited, supplies Dave's work to the rest of the supply chain. So in this example, it supplies Dave's work to the agency, and the agency supplies that work onto the end user. If instead of working through a PSC, Dave was working through an umbrella, the supply chain would look like this. So instead of the Dave Limited PSC, we've now got an umbrella business. But so the rest of the supply chain works in broadly the same way. The work is being done by Dave through an umbrella company this time that's being supplied to the agency and then to the end client. But other than that, the supply chain is broadly the same. So the end user requires work to be carried out, and commonly we'll talk about a situation where there's an agency in the chain. They've been used because they've got a good source of worker. of workers and are able to bring that worker in. But if there wasn't an agency in the chain, then these rules could and normally will apply. It'll just be the end user and then the PSC and Dave, or the end user and an umbrella company and Dave. So the agency might at the moment be paying the PSC direct, and then the PSC will pay the worker. Or they might pay the agency might pay the worker as an employee of the agency themselves with full PAYE applied, or they might use an umbrella company to payroll the worker, again with full PAYE applied. So what is IR35? Well, the old original IR35 rules that have been around for 20 years, it's called IR35 because that stands for Inland Revenue, the old name of HMRC. And it was their notice number 35, IR35. And it says, if someone, so Dave in our example, is acting in the same way as an employee, but working through an intermediary, then they should pay tax on their invoices or on their rate, pretty much like an employee would if they were receiving that rate as a salary instead. So it says if you're pretending essentially not to be an employee because you've put a company in between that you control, then IR35 will intend to tax you as if you were an employee again, and kind of ignoring the legal structure in the supply chain instead. So if you've got a tax advantage from going through your PSC, IR35 intends to remove most or all of it. And the way it works on old IR35 is that we take the invoiced value of the work done, we take 5% off, and we say the remaining 95% is employers' national insurance and gross pay. So perhaps gross pay of 85, 86, 87%, and employers' national insurance on top of that, making up the 95% of the invoice value. And then on old IR35, it's Dave Limited who taxes that income and sends through payroll and sends those taxes to HMRC. So Dave and Dave Limited decides if IR35 applies, and if it does, Dave Limited sends the tax to HMRC. And it's based on the employment status test, or an employment status test. And that's the same in old IR35 and new IR35, or off-payroll, in terms of what people often call it. So the status test, which is deciding whether or not someone's looks like an employee, that's the same test in old and new IR35. And that sounds simple, but what do we consider then? What we say is we've got our supply chain and the entities in it, and there'll be legal agreements between those entities. We simplify that slightly and say essentially we've got Dave doing work for the eventual benefit of the end client, and the end client making payment, a decent proportion of which hopefully will end up back with Dave. What we say is if we ignore the contracts that are in that chain specifically, or don't start with the contracts in the chain, we say, is Dave working? Is work being done in the manner of an employee, or is he working like it's a third-party business-to-business relationship? If Dave is working like an employee, we say he's caught or inside IR35. How do we do that? Well, we imagine a contract between Dave and the end user. So there isn't a contract that would be there. There might be several contracts which make up that chain, but there won't be a contract normally between Dave and the end user. So we imagine one. We base that on the actual contracts in place, but most importantly, the working practices in place. So what I mean by that is if Dave is able to substitute, so he can send someone else instead of him, but the contracts don't say he can, then the court would say, right, substitution is possible, even if the contract says it is not. Now, it's very important that what we're looking at here is, sometimes you're looking for a right in the contract, not actually an actual incidence of the event. But the point here is that working practices can overrule what's in the contract. So then this imagined contract, we say, is it a contract of service, therefore an employment contract, or is it a contract for services, a business-to-business relationship? And as I mentioned already, where working practices and contractual terms differ, the working practices will normally take precedence. So that sounds easy as well, but it's not really. So what do we look at in this imagined contract? So what we have to do is go back through 50 or 60 years of case law. So when people have gone to court before and argued whether they're an employee or not an employee, then cases have ruled whether the court feels it is a situation of employment or not. And features, recurring themes have come out of those court cases, and these recurring themes are as follows. So mutuality of obligation is one thing, and that is a kind of feeling of ongoing responsibilities between the two parties, between the end user and Dave. So if there's a lack of this, that suggests we're not in an employment situation. So what we're looking for here is kind of an obligation by the end user to continue to provide work for Dave to do, and some obligation on Dave to continue to accept that work. If we have a lack of that, that suggests non-employment. So where we've got clearly defined pieces of work with endpoints, and it's very easy for everyone to see if everything's finished, and then there is no expectation of continued work, that sounds like a lack of mutuality of obligation. That doesn't sound like an employment contract. So that would sound like something that was more likely to be outside IR35. Another important one is control, and this is controlling how the work is done. So this is things like, are you required to do everything in a specific order every day, or is a worker allowed to deliver the end product, but in majority of cases in control of how they get that done? If there are strong levels of control in how you work, then that looks more like an employment situation. And then substitution, it's another feature that's looked for very commonly is a right, an unfettered right, which means a right without unreasonable conditions on it, to substitute. So that would be a right for Dave Limited to send someone else instead of Dave. And it's not that the agency should substitute, it's that the PSC, Dave Limited in our example, must have the right to supply a substitute worker. We look at other factors as well, such as financial risk, part and parcel, and we ask ourselves, is the worker in business on their own account? Very recently, we saw this come back in the Kay Adams case, where after an appeal, Kay Adams was found not to be an employee again, mainly because she was working she had an established practice as working as a freelancer. She had a long history of doing so, and it was held by the court that she was clearly, when looking at her, she did appear to be a business in her own account. She was a freelancer and had a long history of that, and that was the most important factor overall in deciding that she was not an employee for the purposes of her case. So the overall position is considered and the decisional status is made, and again that's exemplified in the Kay Adams case. Now, common employment status myths that come out of this. Is it true that all long engagements are caught by IR35? The answer is no. However, the longer an engagement goes on, it is commonly a bigger risk over time that a worker will work more and more like an employee, become part of the furniture, start to move from task to task without new paperwork being done, etc. So long engagements are not by their nature caught. However, the way people tend to work on a longer and longer engagement is likely to get an increased risk of becoming employee-like if they did not start in that position. If you have more than one client, are you definitely outside IR35? The answer to that is no, although the kind of contractor who does have multiple clients is more likely to work in a way which does make them look like an outside IR35 person. Again, this number of clients thing came up in the Kay Adams case recently. But it is important to note, just because you've got two clients, that doesn't mean you're outside. You could be inside for one and outside for the other. Could be inside for both, could be outside for both. If your contract says you're not an employee, are you fine? No. If you're working like an employee, then the fact that your contract has a line in it saying you're not an employee is not by itself going to prevent you from being treated as one. If your agency can substitute you, as noted before, it's the PSC, Dave Limited, that needs the power to do that, not the agency. Is it my agency's problem or my supply chain's problem if my status is incorrect as a contractor? Well, the answer, of course, is that at the moment in the private sector, it's no one's problem except Dave and Dave Limited. But of course, once the reforms come in, the liability can shift around the supply chain, as we'll hear later. So for the private sector right now, pre-6th of April 2021, it's not the agency's problem if status is incorrect. Can an office holder be outside? So someone who's holding the role of financial director, for example, is not going to be accepted by HMRC as outside IR35. By virtue of being an office holder, they'll normally be treated as inside. And can you get a contractor for maternity cover and treat them as outside? Well, here we just need to think fundamentally about what IR35 is. If someone is coming in to cover the work of an employed member of staff and they're not going to do anything different to that, then if you test how they are working, they're going to be working like an employee. So they're going to be inside. Just by virtue of being a temp doesn't make you outside. So that's old IR35. The contractor decides if they're inside or outside of the rules. And if they're inside, they do the taxes differently. The contractor normally pays more tax if inside, and they don't see HMRC doing much enforcement. Doesn't mean HMRC do none, but they don't see a great deal of it. They also see in the contractor press HMRC losing a lot of IR35 status cases. There's no penalty at the moment on the rest of the supply chain outside the public sector if the contractor gets their status wrong. And there's no real risk for end clients or agencies. So HMRC wanted to ensure that the supply chain took more responsibility for the status of contractors than it was doing. So they rebooted the IR35 rules into what's known as off-payroll or new IR35, and they did it first in the public sector. So what they've done broadly, in broad terms, is the responsibility for deciding on the IR35 status of a piece of work, that responsibility moves to the end user in the chain. So that would normally be the bigger business at the top of the chain that needs the work doing. That's true unless that end user is a small business, and we'll talk about that later. The financial risk moves from the contractor to the fee payer. The fee payer is the legal entity that pays the PSC. So if a PSC is still used and it's paid gross, the risk moves to that fee payer if it turns out that the decision was wrong to pay them on a gross basis. It can also move to the end user, and we'll go over how that happens a bit later. The fee payer, their financial risk is that they become liable for underpaid tax and national insurance, or well, indeed, all of the tax and national insurance that should have been deducted from the payment, including employers' national insurance. And therefore, agencies and end clients are taking on a new financial risk as the liability can move back up the chain to the end client. The idea of the legislation is that PAYE or umbrella workers are intended to be outside of scope. So the point here is that if someone is being paid on that basis, these rules shouldn't need to apply because employment taxes are already being paid in full. And it applies in the private sector to work done from the 6th of April 2021. It's not the payment date that matters now, it's when the work was done. And in the public sector, a version of these rules came in 2017. In all of these rules, so old IR35 and the public sector off-payroll changes and the private sector off-payroll changes, the employment status test is the same test. Terminology in this in the new world then on the off-payroll rules. So we have an end client on the left. That was the top of my original supply chain. So that would be a bank or a supermarket or a public sector body like the NHS or something like that. Then we'll have one or more other parties in the chain between that end client and the PSC. What you can see here is that the one that pays the PSC, so it could be agency 4 here, or it could be some other kind of legal entity, they're known as the fee payer. The person paying the PSC is the fee payer. So in the public sector, when this was brought in, public sector end users like the NHS had to comply with these rules from April 2017. In their case, it was for all payments from the 6th of April, slightly different now in the private sector. The end user decided on the status of each assignment, and whoever paid the contractor company, the fee payer on that previous diagram, they'd be liable if they didn't deduct tax and status is later challenged successfully by HMRC. So if there is no agency in between the end user and the PSC, then the end user is the end user and the fee payer. There's no 5% allowance off the rate. In fact, in the public sector, if the end user decided that the assignment was caught and the contractor continued to use their PSC to get paid, then the assignment rate is taxed just like PAYE or an umbrella payment. The contractor's been suffering all the employment taxes that they could suffer on that payment, but they get no rights. That's what the rules say. The end user decides, but is effectively not liable. In the public sector, there was very little in the way of liability transfer. So we end up in this sort of position. So this is what the new rules, this is the decision tree that has to apply to the supply chain. So at the top in the middle, we decide on the assignment status. The end user has to decide on the assignment status and then do some other things, which we'll go over in a minute. And that they have to remain responsible for that decision-making process, even if they outsource parts of it. On the left, if we decide that the piece of work is inside, it looks like an employed piece of work, then firstly, we could offer a permanent role for the worker instead. But of course, we do need to ask ourselves what rate of pay we'll need to pay for that worker to be happy with their lot. Or we could use a recruitment business or an agency if that's how we recruit. And they might either pay them themselves or use an umbrella to payroll them. We need to decide what rate of pay is needed, and that'll partly be a commercial decision just based on how many workers are available. Also, and as noted at the bottom, you'll have to bear in mind that it might be harder to find the right talent if we've got to pay people on an employed basis, especially if other people are managing to pay people not on an employed basis, that rightly or wrongly, depending. The other important thing to say that here is that if you are going to pay through a recruitment business or an agency or an umbrella, you need to be sure that those businesses are credible and safe for you to be involved in your supply chain. You may already be using the agency, so that might not be too difficult. But if you're using an umbrella and you haven't done before, you need to be very sure that that umbrella is a safe partner for you to use in the supply chain. On the right, if we assess and we decide that the piece of work is outside, and that may be how the PSC worker was already treating that income, then we can continue to pay them through the agency if there was an agency before. But we do have to make sure that we take account of the fact we've now got a new financial risk. So we've decided they're outside. Our risk is that that is successfully challenged by HMRC later. And so we have to take steps to protect ourselves from that risk, and we'll go over those risks a bit later on. So, important point to note is that the off-payroll rules are not the same bit of law as the old IR35 rules. So the old IR35 is in something that is a part of the Income Taxes Act known as Chapter 8, and the new ones are Chapter 10. This means that the Chapter 10 rules, there isn't a big volume of tribunals or case law on how those rules operate. There still is lots of case law on employment status generally, but not a volume of case law on how those rules operate. And a key difference in how it's written is that it's clearly in the legislation that the implication is that if if off-payroll applies to an assignment, then it is expected that employers' national insurance will be added to the rate that's been agreed. That's not the same as in Chapter 8, where, of course, what we say is that the workers' PSC deals with all the taxes. So it's very important, therefore, that if a contractor is moved from being on an outside assignment to a different method of engagement, it's got to be very clear and understandable for them that they have changed engagement method and perhaps that the rate has changed. If not, you could leave yourself open to a challenge later from the contractor that their rate hasn't been amended and should have been, and therefore some taxes have been taken out of it unreasonably. What we saw last time around in the public sector was that rates didn't always go up, and of course that's partly a commercial thing, but also it could be people not understanding these rules. And of course the consequences of that can be very significant for workers. So on the left here we have the contractor working originally outside IR35. They're suffering corporation tax and dividend tax, of course. It's not like they earn tax-free, but from that, the take-home pay is obviously it's of a healthy size. They would feel shown on the left-hand side here. If you took the same gross pay in column 2 and taxed it with PAYE and employees' national insurance, take-home pay would reduce, but not by as much as you might think. The point, though, of course, is that anyone paying someone like that also has to suffer employers' national insurance, shown in column 3. And if that is pushed down into the rate that was originally being paid, then you can see the take-home pay in column 4 has shrunk significantly compared to column 1. And still significantly compared to column 2 and 3 as well. So where the supply chain doesn't increase the rate at all, you can see clearly that the worker will end up with a lot less take-home pay than they probably had before. So it's important for bearing that in mind in terms of how your contractors are going to feel about this legislation, but also it's important because this is one of the main motivations why people offering unrealistic take-home pay in the supply chain, such as an umbrella company that's not following the HMRC rules, that's why they're attractive to contractors, and that's why, of course, your messaging has to be very clear, that so you can explain to contractors why they shouldn't be entertaining those, shouldn't be trying to work with those kind of providers. And of course, for you, it's bad reputationally and in other ways, possibly financially, for you to work with those providers as well. So you need to be very careful about who you decide to partner with if you're dealing with the implications of these new rules. So the new final version of the rules that we get in April 21 are as follows. They say for each new assignment a contractor undertakes and each extension of an assignment, and if things change about that assignment, then the end user, if not small, must issue a status determination statement, which confirms the status of each assignment, and they've got to pass that to the next party in the chain, which would commonly be an agency, and to the contractor. If they don't do that, they are liable as the fee payer. So the payment they've made could be subject to tax and national insurance if HMRC are able to show it should have been. So doing a good assessment is key to complying with these rules, as in making sure your employment status test is solid. And also the SDS itself must be issued at the start of a new assignment. If assignments are already in progress, then you need to issue one by the time the rules are implemented. And also I get asked sometimes whether an SDS from last year, from April 2020 or February or March 2020 can be used. It can be used, but only if you are sure that all the conditions that were considered when that original status determination was arrived at are still the same. So yeah, there's nothing in the law that says it cannot be used. I would recommend, though, as good practice would normally be to redo those assessments anyway, because we're a year later and working practices and other things may have changed. The SDS itself, the status determination statement, it should confirm the status. It's the responsibility of the end user. And it confirms the reasons for that status decision as well. If the worker or the business paying the worker or their PSC wants to challenge it, they can, until the last payment for that assignment is made. The end user has 45 days to respond to the challenge, and the reasons should be given for the challenge, and reasons for the response to the challenge should be provided. If that process isn't followed, so if they don't respond in 45 days, for example, the end user could become liable again. It could become the fee payer against the legislation. The SDS is very useful because it will provide reasons for the status decision reached, which allows the contractor and other people to understand why that decision has been made. It also confirms the information normally that has been inputted, and so if any of that's wrong, that can be challenged then. And a good SDS and a good status decision will ensure that only people who are outside IR35 are paid without payroll deductions, and that will protect the supply chain from liability later. It's a good idea, if you haven't done it already, although we only have a few weeks left now, that you sample your contractors. So if you've got a few different types of contractor, have a sample assessed to see what their likely status is, and to see whether or not the simple things you can amend or change to make their status clearer. There's more detail on how SDSs work in the ESM, that's the Employment Status Manual, and it's HMRC's guidance on how they should apply the rules. It is only guidance, of course, it's not the law, but it's worth consulting Edge if you want to see some examples of what HMRC think good practice is. So if you look at ESM 10,000, you'll have an index of different documents, which include these ESM 10,012 and 13. Now, I said earlier, you have to do this if you're unless you're a small end user. So first of all, we have to decide who is the end user. Normally, it's the people at the top of the chain I showed you in the first slide. But sometimes when there's a whole supply of services made, such as the delivery of a whole managed project. So here, for example, you'd be thinking, is someone just supplying me with 5 IT technicians who are skilled in a certain area? Or are they delivering me a whole project, such as adding a new payment capability to my trading website? So did they quote to do that whole thing, or are they just quoted to supply people at a day rate? So if it's a whole service that's being delivered, then the deliverer of that whole service can be the end client instead of the original end client. So just as a random example, if I was an IT business providing a whole project to Tesco, then instead of Tesco being the end user, which is who you might initially assume, it might be the IT consultancy business that supplied that project instead. In that case, it's the IT consultancy business's size that's relevant rather than the normal end user. But in almost all, certainly in most cases, unless there is a clear consultancy arrangement in place, it's going to be the business at the top of the supply chain that's the end user, and therefore whose size is important. The size of the agency or the recruitment business, so unless they are a consultancy, is usually irrelevant. But what makes you small? Well, it's the accounts that are filed in the tax year before the tax year we're concerned with. So for the first year of off-payroll, 6th of April 21 to 5th of April 22, it's the accounts that should have been filed by the end user in the year 6th of April 2020 to the 5th of April 2021. So the tax year we're currently in, immediately before the off-payroll rules come in. So do those accounts meet the small definitions? They can only breach one of these, which is annual turnover of more than 10.2 million, balance sheet assets. That's not the balance sheet overall net asset position, it's the balance sheet assets of over 5.1 million and over 50 employees. There are rules around having a year's grace on some of these and so on. So what you need to do is check the filed accounts and see what size they say they are. But do beware though, because even accountants get this wrong sometimes. But broadly speaking, if those accounts that were filed in the previous tax year say that the company is small, then you'll be small for the tax year you're in for the purposes of these rules. If you are small, you don't have to comply with new IR35. The only requirement you do have is that if someone comes to you and says, are you treating yourself as small for the purposes of off-payroll, you will confirm that you are doing. You don't need to assess contractor status or issue SDSs, and contractors who are working for a small end user just apply the old IR35 rules as they do today. And that end user is the size they are for a whole tax year. You only normally change each 6th of April. There is a requirement that if you issue an SDS and then you become small, you're required to officially withdraw it so that the contractor knows that the IR35 or status compliance is back down to them again. Now, what about overseas supply chain? It's a very common question. We have to ask ourselves, where is the end user business? So we talked about how to decide who is the end user before. Where are they? If they are not UK based and they have no permanent presence in the UK, like a representative office or a branch or an agent operating here, then the new rules don't apply. And if so, the end user doesn't need to do anything, and indeed HMRC probably couldn't make it do anything anyway. The agency can operate as it does today, and the contractor just uses old IR35 rules again. Beware, of course, you can't, if someone's got a UK office, they can't just then invoice from somewhere else and then say that they are an overseas operation. You're looking for that connection to the UK to decide if someone's overseas or not. You also have to ask yourself, where is the contractor? Generally speaking, if Dave, in our original example, if Dave himself is not UK resident, then the old and the new IR35 rules don't apply at all, because there's no UK taxes at risk for the individual, which is what IR35 is really trying to collect. So a genuinely non-UK resident for tax purposes individual should not be in the scope of these new rules. There may be other considerations, of course, though, about paying someone who is overseas. And yeah, so supply chains must be careful with that anyway. There are lots of other considerations outside off payroll. Can you pay a PSC inside IR35? Well, yes, you can. That's indeed what the rules say. They say if you're going to pay the PSC, this is how you must pay them if the assignment is inside. The fee payer, then, the agency, probably, or other intermediary, would set up the worker as a special type of pseudo employee and apply payroll calculations to their net invoice value, that's net VAT, and submit RTI. There is a marker that is put on the RTI report saying this is a kind of pseudo worker, it's an off payroll worker, not a real employee, in inverted commas. The worker's PSC receives net pay, which it can then pay on to the worker without further income taxes being applied. The worker is receiving money in that way, but has no employment rights, no ability to pay into a pension through that income, and no sick pay. But not even the right to a pay slip, which is a very basic right in employment law, because they're not a real employee. So for these reasons, often workers would rather take what I describe as a genuinely employed option, you know, some direct payroll somehow, or working through an umbrella with a real employment contract. So again, this is what we do. We decide at the top whether or not the assignment can be an inside or an outside one, and then we follow through the steps. We do have to bear in mind, as mentioned before, do we need to increase rates of pay for employed options? Or will it, if we don't, will it be very hard to find the right talent? And on the right, we have to make sure that we comply with the rules to avoid the additional financial risks of the new rules. So how do we protect ourselves from liability if we're members of the supply chain? The end user will pass liability down the chain if it does an assessment using reasonable care. There's lots of information about that, again, in the HMRC's guidance, but it means basically taking these rules seriously and trying to do a real status assessment based on current case law. And if you pass that on via an SDS to the right parties. The agency, if there is more than one agency in the chain, will pass liability on if they pass the decision down, having received it, and they can show that they did that. And if payroll type deductions of tax were not made and HMRC is able to show they should have been, this is a very important point, HMRC haven't got an automatic right to collect payroll taxes on the gross payment. They have to show that the assignment was inside. Then they go to the fee payer first for those taxes. If they can't collect from the fee payer, they can go to the top agency in the chain to collect. The law allows them to do that. And if they can't collect there, they can go to the end user as well. So that looks like this. Here we have an end client. They issue an SDS, and that top golden coloured arrow is then passing that to agency 1, who passes it to agency 2, passes it to agency 3, but agency 3 doesn't pass it on to the person paying the PSC. If HMRC come knocking, they might come to the fee payer who will say, I did not receive an SDS. That's why I paid gross. They would then go to agency 3 because agency 3 didn't comply with the law. It didn't pass on the SDS. If they couldn't collect there are powers in the law to move to agency 1. They can go to the top agency in the chain. And if they can't collect there, they have the powers to go to the end client. Now, HMRC have said, as I said, there are powers in the law to move to other parts in the chain, but HMRC have made some statements about when they would seek to use these powers. They've said if they can't collect lower down the chain just because that business doesn't exist anymore, for example, it's just ceased, then they say they won't use these powers. But that is just their guidance. The law does include in it broad powers for collection. The reason they've put those broad powers in is because HMRC want end users to take the rules seriously and not to think that supply chain compliance is someone else's problem. It'll be years before we see how broadly this is applied. So yeah, just so, we have to just proceed with caution there. Of course, the right attitude is to try and do the best status assessments possible and ensure we've got processes in place to meet the requirements of the new law. And of course, use the best supply chain partners we can, people who we know are acting compliantly. End user assessment must be done using this reasonable care, otherwise the liability sits back up with the end user. And that includes not blanketing. What that means is not assessing 1 or 2 contractors and then assuming that those assessments are valid for a large number of contractors. There's information in that in the ESM 10,014. So overall, how are you liable? You're liable if you don't issue an SDS and you should have, and you don't pass it to the right people. You're liable if you can't show you passed on an SDS when you've received it. You're liable if you don't respond to an appeal or a dispute within the time limit. And you're liable if you don't answer the "Are you small?" question. Yeah. So there's lots and lots of ways to become liable. And given all of that, it's not surprising that some people have chosen, initially at least, to just blanket ban PSC. So rather than blanketing when we talk about status assessments, which is assessing 1 or 2 contractors and applying that to a whole group, this is just saying I won't work with PSCs anymore at all. This is a huge commercial risk. You use contractors because you need them, if you're using them at the moment. And most importantly, perhaps, and it's often missed, HMRC themselves accept that most PSC contractors are outside IR35. Their best estimate that they've arrived back at several times is around 2/3 of contractors they think are outside. So the idea that everyone should be banning PSCs just doesn't make any sense. It's not what HMRC expect either. Recent seminars, I've sat on some of them, show that most PSC contractors just don't want a role that's not self-employed. And it's clearly possible to use them in lots of situations. The public sector is using them again, having banned them a lot originally. It's just that you can't always use it. You can't manipulate every situation to be an outside IR35 one, but there are lots of situations that are genuinely outside IR35, so you shouldn't be scared to use those. So yeah, don't manipulate them, especially not with fictional contractual terms, because they will be ignored. So do a high quality assessment. That's the key to success through this legislation. What are your options to get assessments done? You could employ some employment status experts, but obviously that's only available to the largest end client. And of course, now as we speak, only a few weeks before the rules come in, there's not time to do that. You can use CEST, HMRC's assessment tool, but there is some controversy in the marketplace over how good that is. You can get an opinion from a firm of experts. You can get access to other tools. There are several available on the market. And you might use a combination of online questions and then expert intervention on a more manual basis on difficult cases. Another thing to consider for the end client and the rest of the supply chain is to consider whether the current insurance will cover you for risks under this legislation or whether you need to extend it. Be very careful there. And do involve the whole supply chain. If you, for example, as an agency want to get assessments done or be able to help your end client get assessments done, you've got to do something that the end client can work with. So do remember to speak to other parties in the supply chain. To be useful, if you're thinking, how shall I assess? You've got to have a known and acceptable cost for the assessment. It's got to be able to operate quickly at high volumes, because you can have peaks and troughs, such as you approach April 21. It needs to fit into your existing procedures. So where at the moment you might have right to work checks in your procedures, you're going to have another check that needs to be included, which is the, have we done an assessment? Have we complied with Off-payroll? These systems need to be documented and not overridden. So you don't want a situation where you've had an inside assessment done, but then someone is able to override that and allow that person to be paid gross. The whole chain needs to be on side with how you're dealing with assessments. So yeah, lots of considerations there for how you do assessments. So what should you do now if you've not really done very much? You need a project team for Off-payroll if you haven't already got one. You need to identify which contractors you've got in the supply chain and sample assess some, although we may now be at a point where it's time to just assess them all. Consider whether or not there's any working practice and contract changes that you can do that help with status, that make status clearer, or perhaps for those people who might have to work on an employed basis in the future, are there things you can do for them to make them feel better about that in terms of employee benefits. Establish how you're going to do assessments and what systems to use. Will you be able to work with a range of systems? Communicate with the supply chain to understand their levels of awareness, including contractors. Most contractors who are going to be affected by these changes are now aware of it, so there's no need to be scared about talking to them about it. And find out what other people in your sector are doing. That's, often underrated. Do try and find out, if you can, how are other people approaching it? Are other people going to be able to offer outside roles? If they are, you're going to need to be able to as well. You need new workflows to cover, the assessment process, what you do with a dispute, what you do when you extend a contract, and how you evidence that you've complied with the rules. And you need to test those. Obviously, there are other people who'll be able to show you outsourced versions of complying with this. One way or another, your business is going to have to show that it's complying. Do bear in mind how these rules will impact your supply chain partners. Use external experts to assist. And review your supply chain for compliance generally. You working with people probably that you've done due diligence on. If you're adding new people to your supply chain, you need to do due diligence on them. You need to look for accreditation. You need to look for how long businesses have been in existence, and use market intelligence to help you with those decisions. Don't rely on another off-payroll delay. At the time of speaking, we're shortly before the budget. If any delay was to be announced, it would be announced in the budget, but everything HMRC's put out so far has talked about these rules definitely coming in April 21. I'm expecting further guidance from HMRC to be released with the budget. I'm not expecting another delay. So knowing your supply chain is critical, of course. You may use payment intermediaries more from April onwards. You're trusting another business with contractors' wages. It's crucial that you can rely on them. You need long-standing businesses, ideally with a UK base, clearly, and UK tax residency for payroll. You can't just pay someone through some offshore model because the supply chain is in the UK. UK taxes need to be paid. Use market intelligence, of course. There's a huge reputational risk, more now than ever, and it's only going to increase if you get involved in tax schemes or anything like that. Look at the loan charge if you want to see examples of how that can go wrong. And do remember, it is true, if something looks too good to be true on payroll taxes, then it definitely is. There's no clever way to do payroll so that the taxes don't apply. HMRC have put out some indicators that they would expect businesses to use to be mindful of when they're selecting payment partners. And they can be found on ESN 10,032. There's also lots of spotlights and stuff that they've released recently, along with an advertising campaign about making sure that you are using payroll partners who are doing payroll properly. And there's also been recent work on things called mini umbrella companies, or MUCs. This model operates where there's a very small group of people put through one limited company, maybe only 2 or 3 or 4. And these are normally used to exploit the idea that possibly you won't need to register for VAT, or that maybe you can make a claim for employment allowance. HMRC are very focused on these at the moment. And so again, that's a model I'd stay well away from. Quickly, worth noting, of course, contractor rates. Contractors faced with moving off one engagement method onto another one will obviously look at their rates. And it's very important to know, as I mentioned before, Chapter 10 kind of intends, it's implicit in it that employers' national insurance is added to an agreed rate if these rules apply. So if you change engagement method, it would be understandable for that reason, and just for normal reasons, that a contractor might expect an increase in rate to account for this change in method. This is partly because there's often confusion about what a rate really is. You know, you may feel that it's been very clear since day one that the rate paid to the contractor is to include any taxes that the supply chain or the contractor has to suffer with money making its way to the contractor's pocket. But the contractor may well not understand it this way. So you make sure it's important to review how you talk about rates, what you call your rates, whether you're an end user or a recruiter, because the contractor is understandably going to be confused by this. Some of the FCSA code is aimed at making sure that everything is transparent when illustrated to the contractor. So make sure that the illustrations you're giving to your contractors about how they might have to work if they're changing method are clear, transparent, understandable, and don't intend to pull the wool over anyone's eyes. And yeah, so what you want to do if you're moving contractors from one engagement method to another, you want to make sure that in that process, they can be in no doubt that they have changed engagement method and that we're now working in a new way on a new rate. If you wanted as a supply chain, sometimes and often it tends to be for the most critical contractors, the most skilled, the most unusual. Sometimes you might take the view that you want to maintain their take-home pay, even if you have to change their engagement method. This slide just illustrates the idea that it's not just, you don't just add employees' national insurance. You'll have to increase by more than that in order to put the contractor in a position where they still feel like they're as well off as they were before. And if the contractor was able to claim a lot, or needed to, and was able to claim a lot of expenses before when they were working outside IR35, this difference is going to be felt even more strongly because there's very little in the way of expenses you can claim under employment. What do we see in the public sector? Supply chains weren't ready and they didn't understand the new law. It was rushed in. Assessments weren't done, or they were blanketed or done badly. Lots of non-compliant umbrella companies were set up, offering loan schemes to offer high net take-home pay to workers, and some workers did take advantage of them, unfortunately. Or I should say probably some workers were taken advantage of by them, because of course those providers operate like that and then very commonly disappear into the sunset by the time HMRC comes along asking the contractor for more money. End users often try to leave compliance to their agencies, and that was even more true in the public sector changes because it was very hard for the end user to become liable. Rates often weren't increased, especially at low pay rates, and that meant agencies lost margin as margin was squeezed further, margins that are already low at those low pay rates. Agencies didn't commonly have very evolved conversations with end clients about just what impact the contractors were going to feel. And that meant that they weren't able to often have very good conversations with their end clients about putting up rates. End users, they first used CEST, but then maybe used other methods to assess. And then we started to see people actually benefiting in some way from the changes, which was those agencies especially, and then some end users who were able to work with a new assessment method, started to find that then they could attract the best talent again and maybe take advantage, maybe get a competitive advantage from dealing with this change. Commercially, some rates did move, but some did not, and it was at different speeds, and it was based on the reality of the situation in terms of how difficult it was to attract contractors. Obviously, as we go into April 21, with the economy still in dire straits, frankly, commercial pressures might be smaller than they were in 2017, but we'll just have to see how it plays out. I expect more private sector end users to initially panic, and we are seeing that in the final weeks as we approach the deadline. Some will try and offer lots of permanent roles. That is happening in some sectors and for some types of role. But then I do expect, as we saw in the public sector, end users to start to wake up to the fact that they've now either made their talent much more expensive to them, or that less talent is available, less range of talent is available. So I expect them then to start either increasing rates or starting to look again at whether or not they can engage better with the legislation and work with it. There will be more non-compliant offerings that emerge, which will put the whole supply chain at risk. So watch out for those. And we then see a rolling back towards the current status quo. I don't think, I'm not saying everyone that was working through a PSC will be able to work outside. Some of them undoubtedly should not have been, I imagine. But also in some places, an end user just won't be able to get themselves into a safe place to engage outside workers again. But they will feel an impact of that on the cost of those workers and on the talent available. Do expect to see more consultancy type arrangements where, as I've talked about before, people supply whole services rather than just workers at a day rate. So they become the end user themselves. The advantages of that is that the original end user is then not involved in the off-payroll rules. Liability can't be transferred to them if they are indeed not the end user. And also then it will be the size of that consultancy business that matters rather than the size of the original end user. So there's two potential benefits to the supply chain there. The reason I think there will be more of it is that some people will try and set it up as a way to work around the legislation, and that may or may not work, probably won't. But I do expect to see more of it as well, because it is a genuine model that exists already. Sometimes recruiters become an expert in a certain type of project and end up as a consultancy business. Sometimes groups of contractors get together and set up consultancy businesses. So I do expect to see that happen more, because it's a real thing and it gives benefits when looking at this legislation. And same thing in sorry about that. Same thing around statements of work and consultancy arrangements. There'll be some innovation in those areas, but do watch out to make sure that they're real. They're not just manipulating the situation to try and get around. There's no shortcuts through this legislation. Good process is the way to get through the legislation. So in summary, no serious person would suggest that IR35 as it was works well enough, or it doesn't solve the problem it intends to solve. We do agree the legislation needs to work better, and government departments have got stung by these rules as well. So it's not like it's all a private sector problem. It's a problem across the marketplace. We as FCSA do feel there are historic questions to answer around enforcement, and that hasn't helped the compliance level. And there's a lot of work generally going on around employment status. There are things like the Good Work Plan, stuff like that, aiming to deal with the new world of flexible working, the gig economy and so on. There are questions there around employment status that haven't been resolved. And so some people might say that perhaps it would be sensible to sort those out before changing IR35 again. But we are where we are. Legislation is on the statute now. It will come in unless it is specifically taken away. And with a serious approach, good assessments and a renewed focus on supply chain compliance, checking those partners, you can work with the new rules. So we're working with HMRC on improved guidance and education for the sector. We're helping people understand how to move workers to umbrella, but moving people to umbrella does pose a risk for supply chains if you haven't used that solution at scale previously. So the key thing for you is to identify which partners are the safe ones to work with. So do your due diligence, check your reputation, and working successfully with the off-payroll rules will undoubtedly give you a competitive advantage, because you'll be able to work with those people who are outside IR35, whereas running away from the rules will mean you can't. So do look, of course, for FCSA accreditation in your supply chain partners, and that's independently assessed compliance with our code. So doing that alongside your normal due diligence checks is the best way to ensure that you can move forward with whatever solutions you need to working with this legislation in the best possible way. Here are some ways to stay in touch with FCSA, and at this point I will hand back to Phil, and thank you very much.
Chris, thank you for that. That was a really useful run through of what end hirers and agencies can expect to see and to be dealing with from the 6th of April onwards. But of course, it's important that actually what you need to do now is start to understand what your responsibilities are based on what Chris has presented to you. One of those that Chris was very clear on is that you now have to ensure more than ever that you are part of a compliant supply chain. Otherwise, some of the liabilities that Chris has highlighted may come home to haunt you. That doesn't mean blanket banning of PSCs. It doesn't mean blanket banning of umbrellas. It means that you have to do proper due diligence. And as part of that, you have to assure yourselves that you're dealing with compliant supply chain partners. And with that in mind, I, of course, will strongly recommend that you use an FCSA partner wherever that's appropriate in your new supply chain. So you have all the information, you know where we are, and good luck on the 6th of April, and we're here to support you if you need it. Thanks a lot. Bye-bye.